Good morning to all of you. As regards the professional ethics, in 2010, a question was given. Please refer to question number 15. And also it has been repeatedly coming. The question is like this. An advocate appeared in a case on behalf of his sister and himself, and the opposition party raises objection that it will be conflict of interest or it is against to professional ethics, then he can be treated on grounds of the professional misconduct. The question is, you decide. Yes, definitely. So you have to write the brief facts of the issue like this. Definitely, there is an advocate and he has to appear in a case filed by the opposite party. So the opposite party filed a case against him as well as his sister. Therefore, he is appearing. So, can an advocate appear on behalf of his sister or not? This is the main question. The issue is whether an advocate can appear on behalf of his sister. And also another point, whether advocate can appear in his own case. Yes, there is no point. Definitely, an advocate can appear in his own case. There is no problem. Definitely, the law requires, even there is no necessity for an advocate, he can appear. Even section 32 of the Advocates Act also says that any person can be allowed to appear by the court, even though not an advocate. So, according to section 30, so section 30 empowers the advocate to practice in any court of law, like Supreme Court, High Court, or tribunal, or any judicial authority, all these things. Section 30. Section 32 says the court can allow any person to appear in any case, even though he is not enrolled as an advocate. But here the issue is relating to rule number 6 of the Bar Council of India regarding the professional standards. So you may be knowing, according to section 49 of the Advocates Act, Bar Council of India is competent to frame rules. Basing on that, they have framed rules which are incorporated in chapter 2, part 6 of the BCI rules. In this case, in this regard, rule 6 says, advocate should not enter appearance. Advocate should not appear in a court where either the accused or the witnesses or his relatives, like father, mother, brother, sister, cousins, uncle, aunt, so many relations are there. So please remember, so if any of that member is related to him, so it is in his own interest better not to appear in the court. Right. Here, his sister is one of the accused persons, therefore he cannot appear. His sister is one of the defendants, therefore he cannot appear. It is very clear. But you have to write a couple of case laws. So, very recent case law I want to tell you in the first instance. So, there is an advocate by name Matthews Nedumpara of Kerala State. Of course, he is practicing in Bombay as well as in Supreme Court also. This Rule 6, he wanted to extend it to all the courts. Rule 6 says, if your relative is involved in any case in a particular court, you should not appear before the court. But what about the Supreme Court? What about the High Court? There are so many benches. So do you mean to say that the advocate, if his relatives are involved in any case, should he not appear? Suppose if the advocate's son is a judge, can't he appear in the other benches? So this is the problem. So you can read the case as Matthews Nedumpara versus Fali S. Nariman. This is 2019. Fali Nariman is a living legend. Very recently he has demised. Fali Nariman. He is the father of, or he is having illustrious son by name Rohinton F. Nariman. Rohinton Nariman, he was an advocate in Bombay. He rose to the level of Supreme Court Judge. Presently, he is the Supreme Court Justice. So, Fali Nariman wanted to appear in a case in the Supreme Court. Of course, the bench does not consist of Rohinton Nariman. But Matthews Nedumpara says he wants the Rule 6 to be extended to the entire court. That means If any of your relatives are there, you should not appear in the Supreme Court, because even though that bench is not there, he may try to wield his influence. The Supreme Court Justice may try to wield his influence in the case of his relative. Therefore, it is not advisable to appear in any benches of the Supreme Court which is not agreed by the Supreme Court. Of course, this case has been filed before Delhi High Court. Delhi High Court held that advocate should not appear before the particular court where his relative is working, maybe as a witness, his relative is an accused, relative is a judge, but not the entire court. The two, Falin Nariman, he is a legal luminary, and his son is Arif Nariman, he is a Supreme Court judge. So the plaintiff's contention, that is Matthews Redumpura's contention, that the Falin Nariman should not appear in any bench of the Supreme Court as his son is working, is not at all correct. Right. Second case. In High Court on its own motion, versus Mr. N.B. Deshmukh, 2010. So here actually this case is related to the Deshmukh appeared in one case, in a particular case before the bench, and when he did not get the favorable order, actually he started leveling allegations that they are related to so and so, all these things. Actually the relations were not proved. So in such a case, it is a negative example. The relative must be either his father, son, brother, sister, mother, like that. Long distance relatives, you cannot attribute motives to him. Right? So, to conclude, we can say that in view of the above cited case laws and discussions, it is concluded that advocate should not appear on behalf of relative as per Rule 6 of the Bar Council of India rules. Right? So if you write this much, it will be sufficient. Thank you very much.